We've won it on many cases in bankruptcy court, though.
Okay, bankruptcy court doesn't have anything to do with, there's all kinds of other problems that get generated from bankruptcy. We don't discuss bankruptcy. I'm not familiar with bankruptcy law. So yeah, Marty, turn around. There are some things that can be done in bankruptcy. Absolutely. Yes. We don't go into that. Yeah, Gary.
My sister paid cash off for her second trust deed, and we are still fighting and demanding that original note, and it's being wishy-washy since May.
Yes. Everything that goes along with the note goes along with the note. Okay? Do you see that? If you sell your house, does the driveway come with it? The paint on the walls, all the fixtures? Hell, they might even keep the roof. So when you buy something, it's all inclusive. Okay? That's a major issue. Now, you think you got the note back. That's what you believe. Guarantee you did not. The McCaffrey case, the cases in New York, the cases in Florida have proven this conclusively. McCaffrey, 4 original notes. We know that 3 got to be fake. We think all 4 are fake. Judge looked at the bank's attorney and says, get a lawyer. Judge took the attorney's file and put it in the court safe and says, you want to see your file? Set up an appointment with the JA. 4 original notes. Yeah.
That note I got back was endorsed in blank 7 times on the back. Well, it had 7 endorsements on the back, the last one being in blank. And then also I took out a Federal Credit Union mortgage in 1990, and after I lost the house, I asked for the note back in 2003, and I got that note back, and it is an original, and it is not stamped at all on the back. It's from a credit union, though.
Yeah, credit unions are actually not a bank. It's a different, and we have a credit union case. It's a funky situation. It's like the private party thing. When you give somebody something, there was a thing on the internet the other day, and I couldn't get this guy to understand. He was operating on the presumption that if you give somebody something, you can take it back. Not really sure where he got that. When I was a kid, we used to call it being an Indian giver. There's nothing in the law that says when you give somebody something, you can take it back. We find that really prevalent in child support cases. I don't like family law. But in like child support, if you get a divorce, which means you were dumb enough to get married, and I'm sorry about that. Oh, I'm sorry. I did it again. When you do like a child support thing and you send your former spouse a child support, now in most states, if you don't do it through the court or through their private corporation that alters and audits the child support transfer of funds, the receiving party can go in and claim that it was a gift. Yeah, it's a real problem. You can be paying for 3 years. I learned that mistake. But, and they can take you back to court. The nice thing is in my case, in the memo line, I thought she was going to do something funky, and I'd put, I'd said for child support month, blah, 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 so I actually won that case. But if I hadn't, all that could have been considered a gift. When you give somebody something, it's theirs. You can't take it back. If they gave you the house for the promissory note, is it yours? Yes. So here's the issue. If they claim that they want to take it back, then what have they just claimed in law? They never gave it to you. So can you say, well, if you didn't give me the house, I can give you the promissory note, give it back to me. You see what I'm saying? That's what equity in law is about. So if they want to claim, now this is all correct in law. We have a problem in law. It's this horribly evil entity that works for the bank. We call them a judge. And they don't like the law. They like the banks. That's our only issue here. We'll talk about law, then we've got to talk about how we can make the courts follow the law. There's a lot of great theories out there. There's a lot of stuff that should work in law that should work every time. But as we find out, give a caveat here. I don't believe the banks would have ever done this had they not already got the judges in their pocket. That's my belief. I've been doing this a long time, and I study it every day. I don't think the banks would have started taking over America the way they did until they were absolutely certain the judges were already in their pocket. There you go. There you go. No, guys, the microphone.
Is that why in California the judges go, they don't have to produce you the note?
Yes. Yeah. In law, we actually list the UCC there that says once you ask them to present, they must present and exhibit the note to the other. They must. That's the law. And the judges are saying, well, we're just not going to follow that law. I put in a lot of pleadings that I'm dealing with on myself. You know, can I please have a list? Or I'd move the court or get real sarcastic about it, of all the rules the other party's allowed to break, just so I know which laws we're not going to follow. Could you give me a list of the rules that I'm allowed to break? I never get the list, but the judge gets the point. And there's nothing wrong with putting that in a pleading. There's nothing wrong just saying, I move this court to supply me with the list of all the rules and laws the banks are allowed to violate to steal my property. And that'll be excellent in appeal. Judge is going to have a hard time explaining that one. When they give you the house, if they didn't give it to you completely, then you don't have to say that you gave them the note completely. Now, let's jump to the new discovery, because you're going to have to study that more. All of that stuff, okay, guys, this book and that disc that you got has a lot of information on it. Marty? When you're just going to have to go through the disc, and you're going to have to learn this stuff. I can't teach it all in one day. So use the book as a basic outline so you understand a lot of this stuff. Look at the disc. I will guarantee you, for the amount of work that went into this book and that disc, even if you didn't come here, you'd be way ahead of the game if you just go through that disc. You can learn this stuff. Yeah.
And the notes say, and the exchange of the loan, they don't mention the house. They say an exchange of the loan that we give you. Then we give them the note.
Yeah, Cindy will go over that so you understand that. Real quick, you can look at your book. Okay. Yeah, it's the very last page. It's a color diagram. When you understand this, the reason I've got the promissory note on one side and the deed of trust / mortgage on the other, and then they're separated, is because they never were together. If you understand those two documents never were together. Now, I'm going to go into that in just a minute, and we'll prove that. Now, when they go pay to the order of without recourse, does everybody understand what without recourse means? If you get bored, Marty, could you give me some coffee, please? And I've done it a couple times. Okay, understand, I've got a little different attitude than all of you. When I was in maximum security jail at Joe Arpaio's jail, I actually testified against, I wrote the case against Joe Arpaio while I was in jail. Thank you very much. I have a bit of an attitude. I've done time. First person in the history of the U.S. arrested as a terrorist because I had anti-government, human rights, and religious fanatic documents all in one place. Those items that they wouldn't list to court was the Declaration of Independence, the United States Constitution, and the Bible. So I was charged and arrested as a terrorist. Funny me, that whole Christian American thing seems to bother them. I beat that case. I'm also the first person in the history of America to be imprisoned for filing exculpatory evidence, which means proves I'm innocent, in the court. The judge dismissed the case. The prosecutor sealed the dismissal and all the documents, charged me with recording documents in a public office, and put me in maximum security for 8 months. Where is when I'd spent 8 months literally being tortured because they didn't want me testifying against the sheriff. So it was a pretty heinous experience. So I have a tendency to not to be, plus, I've been in the Army and I've been married. Fear's no longer a part of my life. So here's a fun thing to do. Get a check from a friend for like, I don't know, $20, just a comfortable amount, just enough to piss off the teller. And have them write you a check. And then go to cash that check at your own bank, the teller the one you don't like, the girl that's married to a guy that beats her up kind of thing, so she's always taking it out on the rest of us with, external genitalia. So go up to that bank teller, and on the back of that check, sign your name and write, "without recourse." You will get to meet everybody employed by this bank. You will get to meet the bank president, the head of security, the security guard, and probably the police. Without recourse is very, very, very powerful in law. That means if that check's no good, the bank's screwed. Okay? And I'm telling you, don't take my word for it. Get a check. When I tell you you need to do this so you understand something, I really mean you need to do this. Because the physical experience of doing this, you will understand how important these words are. Go to the bank. When it's time to endorse the check to cash it, endorse it on the back and write underneath it, "without recourse." Now, tellers, it's I guess, a decent job. Probably decent paying, pretty comfortable job. They don't really know much about banking. They're clerks. They know this. If that check says "without recourse," don't touch it. Now, that's unlawful. They can't do it. But I'll guarantee you they won't take that check. And they'll make it you don't just put a line through it. You scratch it out to where you can't read any aspect of "without recourse." That's how important this stuff is. So there's a reason they put that on there. Now, understanding that, would you say that that promissory note has been altered or modified? Okay. Once you alter or modify a promissory note, it's toast. It discharges the obligation of the obligor. That's it. You're done. The promissory note's no good. So we do a lot of explanation in that in the book and on the CDs, so you really have to get that and understand it. The concept of when we go back to, okay, they took the house, you should get the note back, you must read the replevin document. The replevin document is, there's two types, there's more than two, but there's two types of replevins that we know in law. Or that we use in law, the replevin indefinite and the replevin incespit. The later being the one where somebody took something they had no rights to and they got to give it back. The former being the replevin indefinite, that yes, they had a legal right to that, whatever it is, at one point in time, and they lost that right, so they must give it back.